Okay, so let us start with the today's class. Now, if you look at the today's class, today we have to discuss two topics in total, right? The first is the joint and the constructive liability, right? And the second is the abetment, right? So these are the two topics. This is topic number 5 and 6 of the law of crime syllabus, okay? 1 to 4 I have already discussed. Now before prelims, I will finish law of crime, and after prelims, I will take a break and then I will again finish. Now, if we talk about liability, right? So when the liability of a person is fastened, right? So the traditional concept is that individually you are liable for your act, right? But our IPC says that no, there are certain circumstances when you are liable, even if you do act in three ways. First, you are doing an act with common intention with everyone else, right? So you're planning together, going to do that act. Second way, that even if you're not planning together, your object is same, okay, then also you will be criminally liable. Or you have not done that act, but your servant have done that particular act. Okay, so it means there are three type of liability will arise even if you do not do that act individually, right? One is referred as joint liability, okay, section 34 onwards. Then we have constructive liability, right? That is basically section 149 onwards, right? And then we have vicarious liability. Now this vicarious liability is directly not provided in IPC. Okay, this vicarious liability is directly not provided in IPC. Okay, now our syllabus only consists of these two, that is your joint liability and constructive liability, nothing else. Okay, now section number 130, sorry, section number 34 to 38, that is your joint liability, and 149 onwards is basically your constructive liability with regard to unlawful assembly, right? Unlawful assembly, there are multiple type of unlawful assembly, right? Now, what to study in that, right? Now, if you look at the first point, that is the meaning of inchoate crime or incomplete crime, or sometimes also referred as preliminary crime. Right? These are the crime which exactly not have led to the commencement, ending of or happening of a particular crime, but it is sort of in a preparation mode. Right? It is in the preparation mode, or something more than the preparation has happened. Right? So it means that these are the act which is first step towards committing a crime, right? So that is why these are referred as preliminary, right? The crime, the act which is about to go a crime, about to become a crime. Understand that particular point? Now, when that act is about to become a crime, then up to where the public policy dictates, or up to where the state dictates that no, now the act have reached to a certain level that it should be punished, right? So that philosophical aspect you have to understand about the inchoate crime. That what is the reasoning behind having this inchoate crime or this preliminary crime? Understand that particular point, right? And this constructive liability, abetment, conspiracy, unlawful assembly, all are the example of inchoate crime. So you have to philosophically understand the meaning of inchoate crime. Understand that particular point. Quite simple. Okay. Then you will come to the meaning of separately these two, differentiate between them, separate sections. Okay. So basically, section differentiate between section 34 and section 149, right? What is the meaning and what is the difference between them? And also understand it with the help of case law, right? You read the cases where there is a clear differentiation between unlawful intention and unlawful object, right? There are other differences also, like in section 149, 5 people is needed. Right now, the question is, how does that 5 people is needed? Okay, so you have to understand, go into very nitty gritty of it. Okay, now there have been a question, suppose there were 10 people going to rob you, right? 7 of them, could not be identified, right? 7 of them flew away, and only 3 of them was caught by the police, right? So, South Lok, there were 7 people, sorry, 10 people, 7 of them could not be caught, and 3 of them was caught. Now the question is that can 3 of them be charged? Now the question is that can 3 of them be charged for an offense under section 149? Answer is yes. Right? Now this is the difference that you have to understand, because there have been multiple times this question. I have given some previous question also. Let me show you. See here. See, can less than 5% be charged and convicted for the offense of unlawful assembly? Right. Now, this is the one question I will discuss here. Only you will understand. See, 5% is required. Now that 5% need not to be apprehended by the police. Right? if the scheme of that particular fact of that particular crime suggests that, okay, there was more than 5%, but only 3 could be apprehended. It means at the time of the commission of the offense, 5% was there. It means the 3 can be charged. But if 5 was only there and 2 was, held to be not guilty under 149, right? Then 3 will be also held not guilty, because less than 5% cannot be charged. Understand that particular point? Meaning, if there were 9 people, 9 लोग थे, या sorry 5 लोग थे, और 5 ही थे total. 5 में से 3 people were, declared not guilty. So rest 2 people cannot be charged in 145, क्योंकि 5 की requirement minimum. लेकिन suppose वहाँ पे 20 थे, उसमें से 5 को charge किया गया, 3 not guilty हो गए. That doesn't mean कि वहाँ 5 लोग नहीं थे. Understand that particular point? It means that 2 guys can still be charged under 149. Right? So when we say that 5% is required, it means that at the time of the commission of the act, more than 5% was there. How many of them got convicted? How many of them got not convicted or could not be apprehended is immaterial. Understand? So that is the one concept you should always remember regarding section 149. Do I make myself clear? Yes, everyone? Very, very simple concept it is, right? This question has been multiple times repeated. Right? This question has been multiple times repeated. Right? So understand that very nicely. Okay, then we have here, then you go to the abatement portion of the syllabus, right? When you go to the abatement portion of the syllabus, read the meaning of abatement, right? What is the purpose of abatement? Why abatement was made a crime, right? And then specifically focus that what would have happened if these things has not been made a crime. Like in the case of English law, there is something called accessory, right? So accessory of a crime is punishable, right? So if you help a particular person in committing a crime, or if you take a gain out of that particular criminal behavior, right, then only you amount to only accessory, right? But in the case of Indian law, obviously it was made by the Britishers for a nation which was not independent, right? So they have made this abatement quite, stricter, right? Conspiracy is a specific crime, and abatement by conspiracy is also made a crime. It means that one act has been made a crime, and attempt to do that act has also been made a crime, right? It means it is more tougher, right? So that philosophical aspect you have to study here, that why abatement was made a crime, right? Yeah, whether it is relevant to have abatement by conspiracy in current circumstances, because already we have conspiracy as a separate crime, right? So in my opinion, we do not need abatement by conspiracy as a separate crime, right? Because if a person is by default covered under conspiracy, then abatement by conspiracy, becomes sort of, infructuous, but still it is a specific offense, right? Then read conspiracy specific in detail and the difference between 120A and abatement by conspiracy, right? So we have conspiracy against waging war against the state, and then we have abatement by conspiracy, right? So these two interplay, you have to go into detail. Okay, right? So these are the only type of question that is asked in these two topics. Okay. Now let us go in detail. I have given you some of the paragraph about constructive liability, right? That constructive liability in criminal law means liability of a person for an offense which he has not actually committed, right? You have committed in group, right? Either with a common object or with a common intention. If it is a common object, it becomes lawful, unlawful assembly. And it is a common intention, it becomes 34 read with some other offenses. Right? Now, it is very different from vicarious liability. It means the liability that you incur when your servant does something wrong. Okay, so that vicarious liability is very different. Okay, and that we have to not study it. Okay, so similarly, I have given you the same thing. Then, also called joint or group liability, constructive liability. I have given you an example here. Okay, then the common intention, right? Section 34. What is the meaning of common intention? Now, here, if you remember, the word act done by several persons in furtherance of common intention. Now, there are a lot of case laws to determine the meaning of furtherance. How do you determine furtherance? Right? Suppose you formed a common intention, right? And the first act you did for determining or for with the aim that I want that common intention to be achieved, right? So that very first act in furtherance, right? Furtherance, what is very important, right? It means you are doing something which will enable the achieving of common intention. Understand? That is the meaning of furtherance, right? So it need not to be the last act. It can be the first act in furtherance of common intention. Right, understand that particular point. Okay, so that part has to be read in very, very great detail, right? Then, important point I have written about section 34 that you need to understand, right? The first important point that it is one of the instances of the criminal constructive liability. Other is 149, the difference between them, right? Second, it is rule of evidence and does not create a substantive offense, okay? Meaning that section 34 is always read with some other section, right? Section 34 read with 299, section 34 read with, some other crime, okay? But section 149 is a specific offense, okay? So there are the, very important difference between them. Similarly, 149, right? It is another instance of constructive liability, and this question itself, right? Multiple that this have been asked. You can less than 5% be convicted under this section, right? So that has to be understood in a very great detail. And an example I have already gave you, okay? Understand that particular point. Now, let us come to the abatement now. If you look at the word abatement, right? Then the abatement words here means to encourage, help, whatever, right? It is given under 17 to 120, right? Now, I will not ask you to read each and every section in detail, not needed for our UPSC purposes, right? So what you have to do, so you have to simply study the meaning of abatement under 107. That's it. Nothing more than that. Okay? Nothing more than that. And there's three ways you can abet something. Okay? These are the three acts which have been laid down, okay, and one of them again is abatement by conspiracy, that you will go into detail, okay. So abatement by thing, in that go mostly abatement by conspiracy, second point, okay. Right? Do not read this too much because the question never comes, okay. I've already told you the question mostly comes abatement by conspiracy and conspiracy to wage war against the state, right? The difference between these two and what are the element that basically coincides, okay. That basically coincides. Now if you look at abatement by conspiracy, when two or more person engaging in a conspiracy for doing a thing, right, an act or not doing an act, and an act or an illegal omission takes place in pursuance of the conspiracy, right? So it means that conspiracy need to be first established, then only we will have abatement to conspiracy. Now conspiracy itself is a crime. Think about it, right? So what you are saying that, okay, this is the final crime, you are conspiring to do that particular crime, that is also an offense, and you are abetting to do conspiracy which will do the final crime, that is also an offense, right? So you have made actually three layers of offenses from single act, right? So that is sort of very, I must say that is very rough actually. Yeah? You should not have these three layers of crime. Now you can have again attempt to abetment to conspiracy. It will be the fourth layer. However, that is not the case, but I am saying just right that you should not have multiple layer to do a particular crime. It should be hardly two layer. Okay, that crime and the associated. Right? That's it. You should not go into that much detail. Okay. Similarly, let us go to some of the previous year. Now here I have given also see. It must be noted that the offense under section 120A, a mere agreement is enough if the agreement is to commit an offense, right? But for the offense under section 107, that is conspiracy to abetment by conspiracy, a mere combination of personal agreement is not enough. An act must also take place, right? So that is a very simple thing. This is the crime, and I am doing a conspiracy, right? And I am doing an abetment to conspiracy, right? Now in the case of abetment to conspiracy, abetment by conspiracy, sorry, right? Here we have to only prove, we have to prove conspiracy as well as an illegal act. Okay, there was a conspiracy and I have done something in furtherance of that particular, and I have abated that conspiracy, right? But in the case of conspiracy, mere agreement is enough, right? Now, how do you prove an agreement? Think about it. So you must have seen in police cases, right, that they come up with a, a laptop, a document, and say that, see, existence of this document indicates that you have conspired, right? You have conspired, right? So basically, conspiracy is a mental element. And until and unless you have something hard which could prove that, okay, conspiracy has happened, it is very tough, difficult to prove that the conspiracy existed, right? Like suppose there are 5 people met together, they only talked about it, but they talked about it and one of them had written a letter that, okay, we have met together and we have decided this. Okay, it means that letter will be now proof of the conspiracy, because conspiracy is a mental element. Understand that particular point, okay? So that nitty-gritty has to be gone into detail and understood, okay? Then let us read some of the questions that we have seen here. So this question number 5 I have already discussed, right? Now question number 4, see here. The section 34 is incorporated in IPC to deal with the cases where it is very difficult to distinguish precisely the part taken by each individual in the criminal act, right? So we have made joint liability a crime, not because we wanted to, but because that there might be a situation where the state is sort of, the state could not establish that who have committed a crime. So in that case, what to do, right? So in that case, we have said that one thing we can do, that we can say that if I could prove a crime against any one of them, red with 34, all of them, the criminal liability could be fastened upon. Right? So it actually makes things easier for the state. Right? So again, it's a very philosophical aspect, right? See, discuss the rationality of this section. Right? So why preliminary offense? Understood, right? So it is basically the efficiency of the state that have been protected by section 34. Right? That the state, sometimes is not so efficient that they could take into account or, practically fasten the criminal liability. So his inefficiency is rewarded. That okay, you don't have to do anything, just prove certain elements and they will, bind criminality on all of them. Okay, that is a very good question, asked in 2015 or 14, I suppose. Then see, common intention from abatement and criminal conspiracy, right? So it is talking about abatement by abatement through conspiracy and normal criminal conspiracy, the 120A and 107. Okay, so always this question is very generic, always asked. Discuss the rules regarding joint and constructive liability in criminal law, right? So you have to write about section 134, 149. Both of them is one is the joint liability, other is the constructive liability. Do you find any distinction between the similar intention and common intention? Yes, there is. Okay, the distinction between similar intention and common intention, right? So common intention means prior meeting of mind. Similar intention do not mean prior meeting of mind, right? You might have a similar, intention which is same, but you have not came together before forming such intention. So that is only similar intention. If you have a similar intention, then section 34 do not apply. It has to be common intention, right? So that distinction has to be, understood in a very nice way. Similarly, the doctrine of combination in crime is that when two or more persons unite to accomplish a criminal object, whether through physical volition or one or all any of preceding severally or collectively, each individual who will contributed to the wrong is in law responsible for the whole in the same way as though performed by himself alone, right? So it is basically saying that what is the philosophical basis of joint liability? Right? So this question and this question almost 50% of them is same, right? So again here you will write that it had been made punishable so that it will be not tough for the state or for the prosecution to prove, right? Because whenever we have two or more people come together to commit a crime, right? So it is very difficult to prove because the mental element is involved, right? So when if the state could prove the criminal liability with respect to one person, one member of the group, and satisfy the requirement of 34, each member of the group would be held criminally liable. Understand that particular point? Okay, now what is the rationale behind it? So the rationale behind it is very simple. The rationale behind it is that the state interest will be protected if all of them is punished. Why? Because even if all of them was not there and only one of them was there, right? Instead of suppose there were 10 people, 9 people did not wanted to commit a crime. So even one people would have been there, he would have committed the crime, right? So it is irrelevant whether 9 people is committing the crime or 1 people is committing the crime. Ultimately, the effect on the society will be same, right? So that is the rationale behind having this joint liability. Okay, the public policy is basically the rationale. Understand that particular point? Okay, so having one evil mind and 10 evil mind is irrelevant because ultimately the effect would be same, right? So if 10 people wants to commit a murder, 1 people wants to commit a murder, the ultimate effect on the society will be same. Understand that particular point, right? So that is the rationale behind it. Okay, so that is a very good question, a very philosophical type question. Okay, done. Yes, so that is what I have to talk today. These two topics, right? Go and open books, right, and just start reading these topics and only study the things that I have told you, right, to study, because that is based on the previous year paper, right? So you need not to go into whole KD Gore or whatever book you have and you start reading the whole end to end, right? That is not required. Understand that particular point? Okay, yeah. So that will be